I do think that you can find something, whether in or out of the practice of law, that you're good at, that you love doing. And I think that's one of the things people talk about, what is happiness. If you're really good at something and you love it, and then, side bonus, you make a bunch of money doing it, I think that goes a long way in your life in saying, I feel fulfilled professionally.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we've got Rod Santomauro joining us. Rod and I connected, not surprisingly, on LinkedIn a few years ago, or maybe even more than a few years ago, Rod. I started getting active on LinkedIn. You have been active on LinkedIn, and I really enjoy the things that you post and how encouraging you are of others. And frankly, the message that you share is one that I hope people follow and appreciate, because you not only share your struggles and how you've come to where you're at now, which we're certainly going to get into, but you also share in a way where it's like, listen, anybody can do this, right? You don't have to be Rod. You don't have to be Sharif. Anybody with the right people around them, with the right determination and the willingness to just never give up, never say no, can live and have a very purposeful and meaningful life, both personally and work-wise. So, Rod, thank you for joining us. I've been looking forward to this for a while. Why don't you take a minute or two and introduce yourself?
Sure. Well, like you said, Sharif, my name's Rod Santomauro. I grew up in Florida. Always wanted to be a lawyer. First lawyer in the family, first one in my family to actually even go to college. So, fast forward to think that, and I know we'll talk a little bit about it, but, to think I'd make partner the day I got sworn in is very humbling, because, I did start from some rudimentary beginnings where there wasn't a big educational push in my family before my generation. So it's not like my dad or mom was a lawyer or my uncle was a lawyer, and that's great for lawyers that have that in their family, but I was really starting from scratch. And I just really knew that I wanted to help people. I knew I could have a good living. I love debate. I got my varsity letter in debate in high school instead of football. So that kind of tells you the nerd level that I was on, right? And it's just something I fell into, and I'm just very fortunate that the first type of law I was exposed to was plaintiff personal injury and consumer justice work back in the early 90s. I just fell in love with it, and I just never looked back. It's been a wonderful journey.
That's awesome. It took me a long time to find plaintiff's personal injury work. And now that I've found it, like I've fallen in love as well. I mean, it really can be just truly rewarding work on so many levels. I mean, you're really helping people. And unlike the criminal side, which the criminal side is certainly important, you're actually able to give a victim something in an effort to try and make them whole. The next best thing, right? So, well, Rod, I mean, I'm familiar with your background. I want the listeners to get a better sense of your background in the legal world. And I know you started as you were a paralegal at one point. I mean, you were doing the grunt work. Like, I remember reading about how you would be the one going out to investigate the scene, taking the photos. You eventually, of course, went into law practice. You then became the director of a large nonprofit, and now you're doing really great work with the lien stuff. Before we get into all that, I don't want to forget this one point. You also are very well dressed. I love your double-sided ties. And tell us more about that. Like, where did that come from? Then let's get into
now I feel like I should have gotten more dressed up for the podcast.
It's okay. I mean, it's a teaser. So when people go and actually check you out,
so when they go and see it,
they're gonna see the real Rod attire.
Yeah, I didn't have a lot of money growing up, and going back to high school, I think 3 out of the 4 years I had the same shirt on in the yearly photo in the yearbook. I was very much an isolationist in that I poured my heart into debate and mock trial and over-prepared, but I wasn't a big fashion person. I wasn't popular in school. I did live in South Florida for several years. I think that started to develop that flair back in the 90s. And then as I got established in the practice and had more means, I said, you know what? I want to dress really nice, but I want to dress differently. And I don't want to dress like a typical lawyer. And, what is a typical lawyer dress like, with khakis and a blazer? And all that's great. But I'm like, I want my clothes and my accessories to be an extension of my personality. Not like, look at me when I walk in a room and look at this, but more like, when you dress well and you dress how you want, and you're wearing something nice or you think is nice, you feel better about yourself going into the room or going into the courtroom, or meeting with a client or going out on a date. And I just really got comfortable with looking differently. So I started with bold colors. I started with purples and pinks and reds against different colors. And it's just something that over the past 10 or 15 years, I would say, I've really took an interest in fashion. I feel better about myself when I dress like that. And it does, as a byproduct, happen to be memorable for people. But I think the main reason for doing it is it's kind of like a reflection of me and my personality. And I think it really, especially whether it's opposing counsel or in a corporate setting or even out socially, it really is disarming to who you're interacting with. And I think it brings some levity and some ease to sometimes what can be tough or not so easy conversations or uncomfortable situations. So that's just kind of been my jam the past 10 years or so.
Yeah, I love it. So, and to me, what I hear when you're saying that is like, that's you. And you have no fear in being you. And in some ways that manifests in the type of clothes that you wear.
Correct.
We talk about on this podcast, we talk about this subject all the time. We don't need you to be the best Jerry Spence. We don't need you to be the best Mark Lanier. We need you to be the best version of you. And when in everyday life, in the courtroom, regardless, right? And that authenticity is what allows you to connect with the client, connect with the jury, connect with the judge, and get real results. Tell us a little bit about that journey for you. Cause I'm of the belief that like, it doesn't just happen, right? Like, I mean, maybe some people are lucky, but it's taken time and work for me. And the way that I phrase it is like, just to kind of get over myself. I'm not that important, right? Like, I don't need to pretend to be this person or that person. And for me, it's been lots of therapy. It's been learning things the hard way, failure, and learning lessons from that. I did do the Jerry Spence thing for 3 weeks out in Wyoming, which was great. And anyways, I've come to learn and embrace that the more truer I can be to myself and allow people to see me for who I am, chances are the easier time I'm going to have connecting. And chances are we're actually not too terribly different. I mean, now when he's on our podcast, oftentimes we'll talk about and he'll say, you know what, 99.9% of every human is exactly the same from a genetical makeup, right? So we all have the same fears, anxieties, hopes, dreams, all that, or some version of it. To get to the point where you started feeling comfortable breaking the mold when it came to the clothes that you decided to wear and being vocal and visible on platforms like LinkedIn in maybe what some would consider a unconventional way. What did it take to get there?
It took a lot of humbling and some massive, massive setbacks. When I started law school in Florida, I made the decision because I wanted to live at home with my family, who I remain close with now. I wanted to go to law school at night and clerk in a law firm during the day, which I was already doing before I started law school. So I made the calculated risk and decision to go and do an unaccredited law school with the anticipation that this school would be accredited by the time of graduation, which you needed to be able to take the bar in Florida. Long story shorter, I mean, you can write a book on this, and one day I may, who knows, but there were 111 of us, and we all graduated, and the school wasn't accredited yet. And we stretched it out the best we could, ethically, 5 years. The Florida Supreme Court said we could take the bar. If we were accredited within 12 months of graduation, they would release those scores. And we didn't even think about what would happen if we weren't. We had every indication that would be accredited by the ABA standards. There was a lot of different things going on with the ABA back then, and how they decided who got accredited and who didn't. And it turns out we got accredited 18 months after graduation, not 12. So we're waiting for our bar exam scores for 18 months, not the 6 weeks peak we usually wait. And then we had to wait another 6 months for the Supreme Court of Florida to make a decision. And they decided that the rule is the rule. It's black letter law established in precedent. You weren't accredited within 12 months. We're going to destroy your scores. You're not going to know how you did on the bar exam. And if you want to practice law in Florida, you got to go to law school all over again. So I actually went to law school twice. And of course, graduated the second time, took the bar, passed it no problem, which makes me think, how did I do the first time? I'll never know. It's been 25 years now. But that was very, very humbling, because I would wear suits as a paralegal during the day in the mid 90s. I'd go to law school at night. I'd look like a lawyer. I'd sound like a lawyer. I'd meet with clients. I'd prep them for depots. I'd prep them for trial, all under the supervision of the partners. I'd go sign them up anywhere, but I couldn't practice law. And that was a very challenging time, because what I had wanted to do my whole life up until then, I felt was decided by other people that had never been to the school, that reversed psych committee decisions that said they should be accredited, and going to law school a second time. So people ask me, Rod, would you do it if you had to do it all over again? And I say no, only because I already did it all over again. I graduated the first time, took the bar, and I had to ask myself then, before I was even a licensed lawyer, would I do it again? And I just knew that if I didn't, I'd regret it for the rest of my life, because I really did want to legally and ethically represent people and help people, not for title's sake, but I wanted to be a lawyer. I wanted the privileges and the responsibilities that go with that. And I just knew I'd have a lifetime of regret if I didn't. So that's a long-winded way of saying that was kind of the watershed moment in my life, where I had to make a decision. Do I go down a different road, or do I stay on the path and do what I just did for 5 years all over again? And I did. And I think that's one of the main reasons I did so well right when I came out, because I had a book of business. Clients trusted me, doctors trusted me, and I got sent a large volume of business, the day after I got sworn in. And that's probably one of the few reasons why I did make partner in a small firm, is because I had a book to bring with me, and I wasn't a liability. I was an asset, and I could make a firm money, a lot of money, my first year out, quote unquote.
I had a similar experience after going to a big law firm downtown here in Richmond. And I remember when I left and decided to leave, kind of having that gut punch of like, well, do I keep going this route? Like, why did I go to law school? Do I really want to be a lawyer? Like, what am I going to do? And for me, it ultimately led to doubling down on trial work. And I'm glad I did, because it's worked out. But I think similar to you, and correct me if I'm wrong, in that time period, it was also the life lesson of, I am responsible for my own career. I am responsible for my own happiness. I cannot rely on others to provide that for me. And it sounds like that was when you learned that the Supreme Court wouldn't put you guys through. Like, it sounds like you kind of had that same kind of aha moment, like, this is on me. And so I'm going to be me, and this is what I want to do, and I'm going to do it. Does that sound about right?
It is. I used to say, I think I wouldn't let the inaction of others negatively impact my dreams. So no, I'm 110% with you. That resonates. I'm empathetic to that. I mean, that definitely was, that kind of a feeling. You see a lot of stuff like on LinkedIn now, nobody's coming to save you, right? But we were living it before it was a mantra or a saying, right? I mean, we're grown-ups. We're adult men and women, and we're responsible for our own actions or inactions. And depending on how you're brought up, depending on your beliefs, depending on the environment when you grow up, some people realize that sooner than others, but some don't ever realize it. They don't need to, they don't want to, but Yeah. My old partner, in one of the articles that was written about the whole accreditation saga, he said, I went to the school of hard knocks. I mean, I'm not a fan of that phrase, but I mean, I think it's true. And I think, too, in the law, as much as we talk about colleagues and camaraderie and esprit de corps, there is a level of independence that has to be exercised in your daily day-to-day practice, where you can bounce things off of somebody and you can banter back and forth, but in the end, it's your law license, it's your signature on the pleading, it's your signature on the form, and you're not going to be able to blame somebody else. It's our obligation, it's part of our oath, whether, to me, in my humble opinion, whether you're practicing or not. So yeah, I think that's all very important. I actually have a LinkedIn post I've been drafting coming out later this week talking about that oath of attorney, and no matter what you're doing or what stage of the practice you're in or not practicing, what that oath should mean. And there's a lot of independence within that. We are a self-regulating profession. And I think with that comes a lot of freedom, but a lot of responsibility as well.
One of the really cool things about the practice area, at least we've found ourselves in, is we're also very much results based, right? Like, I don't care where you went to law school. Doesn't matter to me. Like, right. I care. Do you care about your clients? And does that manifest itself in you putting in the work? Are you self-educating? Are you going to conferences? Are you tuning into podcasts to learn from others? And I'm convinced, Rod, and I'm sure you'd agree with me on this, that those who are consistently getting good results for their clients, when you go to one of those trainings, they're there, right? They're there, right? They're willing to help. They're willing to share. They're reading the next book, right? They're always learning. And that's one of the cool things about this practice. It's like, for someone who is willing to put in the work, like, you can make a difference in people's lives. And in doing so, you can really advance your own career.
Absolutely. I never got the best grades. And obviously I went to a school that was accredited the second time, but it wasn't a Harvard or Yale or Georgetown. But I knew how to bring in business, and I was empathetic, and I over-prepared. A lot of times I beat out, especially early in my career, other attorneys more credentialed, board certified, only because I over-prepared and I out-prepared. And I treated every motion like a trial and really, really, really focused on making sure I was over-prepared, because I learned earlier in high school and college during those debate and mock trial, those formative years, when I went up against individuals and teams that were smarter than me. Wait a second, I think I found something here. I'm just going to out-prepare them. I'm just going to be ready for anything. Now, you can't sustain that, I don't think, every day for decades. And I think hence one of the reasons I'm no longer actively practicing every day. But I do think that you can find something, whether in or out of the practice of law, that you're good at, that you love doing. And I think that's one of the things people talk about. What is happiness? If you're really good at something and you love it, and then, side bonus, you make a bunch of money doing it, I think that goes a long way in your life in saying, I feel fulfilled professionally.
Absolutely. Well, we're getting deep, aren't we?
Yeah.
I know.
That's all right.
I like it. This is good stuff. Well, let's talk about a little bit what you're doing now, Rod. I did not have the privilege of knowing you when you were practicing, but I know that after practicing, you led a nonprofit, which I'm happy to chat about here for a minute. But I also want to learn and make sure our listeners understand, like, what you're doing now, because it's very, very important work that I think isn't really noticed by many.
So Synergy, I've been there just under 13 years. I was introduced to it by the founder, Jason Lazarus. Jason was a dear friend of mine in Florida, also a practicing attorney. And I was practicing, and he was in the structured settlement world at the time. And we got to know each other. And then I moved to DC back in 2008 or so, and we kept in touch. We were like good friends by that time. I was the executive director of this large nonprofit in DC, and we kept in touch. He said, hey, I'm starting this new company. It's going to be lien resolution. It's going to be Medicare compliance. We're going to hire the best of the best from all the subrogation companies, and we're going to do a reduced cap contingency on the fee so it doesn't touch the attorney's fee. And we're going to make a real positive difference injury victims' lives and net them more money without costing the lawyer a penny or any of their time. And he said, do you want to join me? And at the time, besides, forget about losing my title, I was, again, that's a side note. I mean, a huge cut in pay, a brand new, basically startup company, but with somebody I trusted and with a few other gentlemen that I had been in the industry for a while, I said, okay, I'll do it. And we started with 9 people total. I was the last of 5 in leadership. And then as the years progressed, I got into more of a sales role from operations. I was a chief executive officer, and then I went into sales. And now I've kind of really found my niche. Is it niche or niche? I don't know. I never know how you say that.
Kind of like niche. Niche is, I mean, who knows? I could be completely wrong.
Niche. I found my thing, right? So
yeah,
I don't really sell anymore. I consult. And I'm not saying that for a play on words, but half my day I'm on listservs giving free advice about ERISA, FEBA, TRICARE, Medicaid, Medicare. The other part of the day I'm doing CLEs. I'm doing continuing legal education classes for law firms, for different trial lawyer associations. And I'm really one of the main faces of Synergy that are out there talking about all the good work we do. But just as important, if not more important than that, I am teaching attorneys what many of them respectfully think they know, and they have no idea, and trying to help them get to the point where they understand the significance of lien resolution and Medicare compliance before it's too late. And by too late, I mean they get sued, the client's benefits get cut off. I mean, we can go as deep or shallow as you want, but there's a lot of good personal injury lawyers, and I can say this because we're 2 of them, that think they know all about liens and what they have to do, and they don't. And they're wrong. And it won't catch up with them now. It'll catch up with them 6 months, a year, 2 years from now, when their client gets sued or when the client's benefits get cut off or non-compliance with the plan. There's a lot in that. So I spend the majority of my day humbly teaching other lawyers about what to look for, what not to look for, and really kind of stay away from selling. I let the products and the knowledge speak for itself. And now we have just under 100 people at Synergy all over the country. And we've only done 100% plaintiff work ever, which we're proud of. So it's where our interests are aligned with plaintiff lawyers. And I don't represent injury victims anymore. I represent the injury lawyers. So it's been a nice kind of full circle moment. So that's what I've been doing with Synergy. And I anticipate I will continue doing that based on where I'm at and where I've been and where I've headed with them. But it's been a great journey, not all easy, but I think I finally found that sweet spot where, I can earn a very good living and help a lot of people and get injury victims a lot more money with 0 downtime from the lawyer. So the lawyer can work on practicing law and bringing in work and doing what they were trained to do versus spending hours every week on the phone with Medicare, with Medicaid, arguing with some adjuster from several company about the language in the plan of a health insurance benefit policy. So we do all that for the lawyer, and we've done well, and we'll continue to do well.
Rod, tell us about a time where, and I'm sure you probably can't even keep track of how many times this has happened, but where you and your team have been able to make a significant difference for an injury victim.
Oh yeah. I can just give you one example. We have them every day, but I think bringing it closer to home, we had a death case in Maryland. We were handling for a law firm client of ours, and the Maryland Medicaid lien was, I think, 7.1 million. It was just a devastating case. You can imagine when the medicals get that high, you're dealing with, a catastrophic birth injury. You're dealing with something that no amount of money can replace that, but you can get the care that's needed. You can do all these other things. And we found a lot of deficiencies within the language, within the Medicaid plan, because each state has more than one type of Medicaid. It was state-based, and we found some ways to be able to chop that down with the weaknesses, and we got the lien down to, I think, $52,000. So we had a savings of
You
basically
went 7 point some million to 50 grand.
We did. There's a lot of different things in the plan language. And it doesn't necessarily just apply to Medicaid, but there's all these doctrines and language that they put in or not put in. And it was really strategizing with the law firm about what they were claiming and what they weren't. But that was one of the largest results that I've had or been involved in, with like a $7 million reduction. It doesn't happen every case, right? Far from that. But we had a team of individuals at Synergy that worked at the related subrogation companies. So they knew the ins and outs. They knew the people involved. They knew the pain points of this MCO. So that's the kind of thing where it's a huge number. Now, I will also tell you on the other side, I had one last week. It was a $14,000 self-funded ERISA lien. They had very good recovery rates. We found some language in the plan documents. Virginia, which is anti-subro, it turns out we could prove that it was fully insured, not self-funded, so it would default to state law. And since Virginia is anti-subro, we got it waived. That $14,000 waiver meant so much to the client. I don't dare say as much as a $7 million reduction we had on the other case, but you can have a case that has a waiver of a small amount or a significant reduction of a very large amount, and the injury victim or the family will feel the same type of relief because of the amount of money involved. In other words, it's all relative, right? If you've got $30 million or you've got $50,000 on the flip side, and I'm just making up those numbers, but you have a limited amount of resources to work with, that $14,000 waiver is huge, because in a lot of cases, the client wouldn't get anything. And with Medicare, the attorney will get their fees and costs, but it can end up leaving the client with nothing. So that's where we come in and have all these creative ways to follow the regs and the statutes and to get more money back for injury victims. So yeah, they run the gamut, but I think those are two examples, and I felt joy in both of those examples, even though one was exponentially so much larger than the other one, because I knew with both families it made such a positive impact. And that's what we're all about. It's not just the amount of money, it's what are you doing for the family? And we cap our fees. So for instance, we charge 15% of what we save as our fee. It's a client cost. But, and I'm saying this for a reason, not to sell, but just to demonstrate, we cap our fee in every single case. Our fee is never more than an amount equal to 15% of what the client will net. So you know how you're practicing a lot of times, I know I wouldn't take more in a fee than the client would net. At Synergy, we're even more conservative than that. We want to make sure that if we're hired, if we're retained, the only mathematical end result is the client will net more money. And with that significant fee cap, we're able to do that. So we make sure that if there is a situation where our 15% that we've earned is an amount equal to more than 15% of the check you give your client at the end of the case, we're going to chop our fee down, no questions asked, to match that 15%. We want every client to net more, significantly more, when we're involved. So that's kind of the mindset. That's the exemplification, I think, through those two cases. We just want the best result possible and have the best result for the family or person.
What's your interactions like with the clients? And I ask that because I know I would guess that the lawyers, for the most part, are probably having the actual conversations with the clients, but I imagine in maybe some exceptional circumstances, maybe you're on the phone with the family. Does that happen?
Once in a while. I mean, we all have those clients that are I'll just say they're very hands-on, right? They want to know everything about everything. They want to, we've had it where they want to interview our subrogation experts at Synergy. And I'm like, all right, we'll coordinate something, but usually, so the answer is yes, we'll do that on occasion, but usually the lawyer has a good enough relationship with the client and they have a relationship with me where they know Right. I'm just going to tell the client that you're going to get a better result on the lien than I will. I can focus on the case and save time and money. It's not going to cost me any of my fee, and the client knows they're going to net more money. So a lot of times, just long story short, here's a perfect simple example. And this, a lot of times, and I'm saying this specific example because I think this is what eliminates that request for a call from the injury victim. You've got $100,000 ERISA lien. Let's say we chop it down by $50,000. That's 50%. Our fee would be $7,500, which is 15% of that $50,000 reduction. So the client would have paid $100,000. Instead, they're going to pay $50,000 for the lien, $7,500 to Synergy. So they're going to net $42,500. Why wouldn't you hire Synergy? And with that, the light will go off if it hasn't already, and then the injury victim will say, hey, if I'm only going to make or net more money, go ahead and involve these people. So that's a long-winded way of saying, yes, we do get involved, but we make it clear we want the attorney on the phone. And even though we have lawyers at Synergy, we're not a law firm, so we don't give legal advice and we don't represent injury victims. Plus, as you know from practicing for a while, we get on the phone, or you have a third-party expert get on the phone with an injury victim, and I say it respectfully, and sometimes what they want to hear is not what's said. And then the injury victim ends up calling Sharif and saying all these things. And then they call us and they're, well, we never said that. So we're like, you know what? We're in a time and world of efficiency. Mr. Gray, you're going to be on the phone with your client. We're going to have our team on and we're all going to listen at the same time. And then that usually takes care of that. So, yeah, but once in a while.
It's awesome. Well, let's break it down a little bit then. So, because not all of our listeners are trial lawyers. And that said, I mean, even trial lawyers, myself included, like I'm a big believer in let's get really good at one thing and then focus on that, right? Let's not deviate. So when it comes to complicated lien questions, I don't try and answer them. I go and look for an answer from someone who actually knows what they're doing. Same thing when it comes to settlement consultants. Same thing when it comes to focus group stuff, right? And I think I'm biased, but I think that is a good approach to have. When we need help, go find the expert, right?
Right.
Let's do just a basic rundown of what is this thing called a lien? I mean, we hear personal injury case. We understand that there's a likely contingency fee when it comes for the attorneys. And then we think that there can be some expenses that are advanced by the law firm. But then when clients or potential prospective clients hear that their health insurance or there could be this thing called a lien, that's where things go crazy. And I myself have trouble sometimes explaining listen, don't worry, this is not like a lien on your house. This is a
Right.
settlement and they can be negotiated and there's so many different variations. If you were sitting down with somebody who just got injured in a car wreck and had to explain what a lien is, what would you tell them?
Sure. And I've done it many times, right? Back in my day as a plaintiff trial lawyer. And it's gotten more complicated since then for the past 15 or 20 years. But what I would say is there is a third party that has a legal attachment or a debt, something that's attached to your settlement, that by the statute or by the case law, or I tell a client by the rules, we have to pay them back. And if we don't pay them back, there could be ramifications for you and or for me, depending on the lien type. So what I want to do is I want to get this obligation that you have reduced as much as possible and get it honored so that the things that would happen if you didn't do it, cutting off future medical care for a material breach of the policy, suing for double damages if it's Medicare Advantage, suing for double damages and referring you to the Department of Treasury if it's traditional Medicare A and B. I'm going to prevent that from happening, but I want you, Mr. or Mrs. Client, to understand that this lien is something that comes by way of the agreement you made when you signed up for this health insurance. It's an agreement you made that you probably don't even know about when you signed up for Medicare or for a Medicare Advantage plan. It's in the plan documents, and I can show those to you, Mr. or Mrs. Client, but you received benefits, or you're going to receive benefits. And when you accept those benefits, you're accepting yourself and binding yourself to a contract within that particular type of lien or type of scenario. And if it's the military, even more so. So I say it's a constructive or actual obligation. I don't use those words with injury clients, depending on how savvy they are, but I make it clear that by you obtaining certain benefits that, by the way, you've paid for, you are obligating yourself to repay certain things. And if you don't, there's repercussions ranging from minimal to dramatic. But either I'm going to work on that for you, or I'm going to hire an expert that does this every day, all day, so that you don't have to worry about it and I don't have to worry about it. But I have an ethical and legal obligation to tell you about the obligations you have through me, because if I don't tell you, no one else will. So that's kind of, depending on the sophistication level of any given client, probably along the lines of something what I would say.
Makes a lot of sense. I like how you framed it, Rod, as like a contractual obligation. And because a lot of times when I'm having that conversation, and I don't do nearly as good of a job as what you just did, but I get the question of like, well, this isn't fair. I mean, like, what do you mean? My health, I pay my premiums, like my health insurance is now going to take part of the settlement. That doesn't make any sense. And that's unjust, right? Like, I don't want them to take all the money, And I'm like, and I tell them like, it is what it is. Like, I get it. Right. But the framing it like a contractual obligation makes sense, regardless of whether we think these liens are justified or not justified, more ethically, all that stuff. Right. Like, but saying like, unfortunately, that by having this type of insurance or by accepting these benefits, you likely or not likely, you did, and you just didn't know it, but you agreed that in the event that you get into a situation like this, that you have the right to recover some of that money.
Yeah. And I would you can also make the example when you sign up for a credit card, when you go to a football game or a baseball game, and there's an assumption of the risk, or a carriage contract with the cruise ships where you don't know it, but you're automatically reducing the statute of limitations to like 3 or 6 months from years for a negligence case for the state you're in. I try when I need to or needed to, I will use examples that a client would be familiar with, especially if I know if they like sports or they like to travel. I use the example of a plane ticket or a cruise ticket or a train ticket or a rental car agreement. Like, you signed off on one thing, but you obligated yourself to 100 things when you did that. And the consideration for that, or the benefit of that, is enjoying that particular product or that particular thing.
What's the incentive for lien holders to be open to negotiation?
Well, it depends the type of lien you're talking about. Some liens, there's not very much wiggle room. Other types of liens, there are. I think generally speaking, lien holders, and I'm biased, they need to be understanding, because the personal injury lawyer becomes the glorified bill collector. If there is no settlement or not enough money,
they don't get paid.
They ain't getting paid. So that's why we like to get cases, especially, I mean, we take them when we're settled, but we have more leverage when they're not yet settled. We can build a rapport with the adjuster. We can start to look at what's related, what's not related, start getting a strategy together. But the incentive is you can get something or nothing. Now, Medicare Advantage, FEBA plans, Federal Employee Health Benefit Act plans, of which there's millions of them, especially here in the Mid-Atlantic. It's for federal employees. They all, by statute and by case law, have very strong recovery rights. So on the flip side of what I just said, this subrogation analyst, because we have like 30 or 40 of them at Synergy, they get bonused on the amount of money that they bring in. So the harder they fight and the more money they bring in, the more money they get paid. They love personal injury lawyers that on self-funded or ERISA liens, which have strong recovery rights, but you can still reduce them. The adjuster will say, oh, it's self-funded ERISA, you have to pay 100%. And the attorney just pays. The attorney just pays because they want to get the case over with and the client won't complain. So they're going to pay the lien in full and move on. They want to get the money in their trust account and everything else. That's not the way to do it. These adjusters have 500 to 800 files each. When you're a thorn in their side, that's when and there's tactics, we can talk about separately, or you can look at one of my CLEs through VTLA or something that talks about this. But there's ways to reduce the liens, but the incentive is for the subrogation analysts, they get bonus based on, and commission based on the amount of money that they collect. And the more money they collect and the more that they collect at full value on a lien, the more money they get. Now, they can refer it to counsel, inside or outside counsel, if the personal injury lawyer's not cooperating. And there's certain mechanisms that can be triggered by these plans for not cooperating. But to me, even though it's a confrontational and adversarial system by nature, and you can look at these subrogation companies as a defendant because they are somebody that you're going to have to deal with at the end of the case. I think it works out more when you have a subrogation adjuster that is willing to compromise. That way, everybody can get paid versus just one or the other. And you have those extremes too. And then the last point on that, Sharif, is sometimes the adjusters won't have a choice. If they're dealing with plan language that is very weak and they have weak recovery rights, they may not be entitled to anything. And if they act like they do and they don't, we remember that for the next time. So there's a lot of times when these subrogation analysts, they're very highly trained, but very narrowly focused. And if you're outside of that narrow focus, they get lost. So we make sure that inures to our clients, the injury victims benefits and the law firm's benefit. But sometimes they just won't have, a lot of times they won't have a choice. The subrogation analysts, they're dealt with the hand they're given. They're dealt with the plans that they're representing. And if those plans don't have good language in them or weak language or say or don't say certain things, that's when we jump all over it and make sure we say, hey, look, you don't have a right to recovery here, or this 1/3, 1/3, 1/3. There's a joke. We should be getting 80% off of this lien, and here's why. So that's why it's important to have people work on these that actually know what they're talking about and know the pain points.
That's right. And be that thorn, right? I mean, coming full circle back to kind of trial work, I'm a big believer, and our firm's a big believer, that when we don't get discovery timely, we do our deficiency letter, we file a motion to compel. They don't answer all the questions we've asked, we file a motion to compel. The trial's coming up, we're not just going without filing motions and eliminate. You're going to get 3, 4, 5. We're always driving forward. We want, not necessarily in an effort to be a thorn. The goal isn't just to be a thorn. The goal is to push, to find the leverage, to dig so we can get our client in the best possible position. It sounds like you guys are trying to do the exact same thing.
It's the exact same thing. And to your point, like I know in plaintiff's work, we're responsible for pushing the case forward, right? The defense is billing by the hour. They get paid win, lose, or draw. We, as the advocate representing the plaintiff, we have to push forward. And a lot of times it's the same thing with the lien, because these lien holders that have very strong recovery rights, they know they're going to get paid or they're going to sue the client, or they're going to get paid or they're going to cut off benefits for a breach of the plan language as a material breach if they don't follow what's the instructions in the plan. So our job, and we have a whole nother team besides our subrogation analysts, and their job is to push. Their job is to follow up, email, fax, phone, letter, been a week, been 2 weeks, been 3 weeks, been 4 weeks. And with certain types of liens, like self-funded ERISA liens, when they don't respond timely, there's United States codes and statutes that allow you to get penalties against the amount of the lien legally and ethically owed for their non-compliance. So in certain situations, not all, of course, but in certain situations, you can use your follow-up as a way to get the lien reduced without the adjuster even knowing. And then by the time they figure it out, it's too late. And we're like, well, you should know the statute on providing us plan documents. I mean, you've done this for 20 years. It's not our job to tell you what your job is. You didn't give us what we needed.
Yeah.
You didn't give us what the statute said.
This is exactly like trial work. Like let me give you a quick example. And I know, well, we're coming close to the end, but like, for example, we've got a trip and fall case right now pending in Petersburg. And amazing client, beautiful lady, just broke her arm in multiple places. Now has a titanium plate in her arm. Anyways, it was once just a trip and fall case, right? We found out that the company who was operating the gas station where this incident happened, 3 to 4 months after the lawsuit was filed, divested, emptied that company. So now they have no assets. So what has it turned into? It's turned into a fraudulent transfer case, and we are in the process now of amending the complaint. So this is no longer just a trip and fall case. This is a case where the company that once they were sued, what did they do? They went and shut down that business to protect their own pockets. And this, to me, what you're telling me is exactly the same thing, right? Like, oh,
Yeah.
all of a sudden you didn't provide those plan documents pursuant to code. And so now you don't have this same right to recovery, right? And so it's all about finding the leverage angles. And I think ultimately, like, I genuinely believe that is ultimately the difference between a good and a great plaintiff's attorney, is whether they're going to kind of just be reactive and attempt to work the case like everyone else, or whether they're going to be proactive and find the leverage points they need to ultimately, when you get into that courtroom, make it very clear that we're here not because of us, we're here because of the defense. They're the unreasonable, right? And so,
there's a reason why we are also called advocates. They push forward, they pursue.
you just have to get after it. And there's no, and I don't care how smart you are, right? There's no substitute for the hard work, the willingness to learn, right? Well, Rod, this has been awesome. So I know we've been planning on this for a while, so it was super great to have you. Before I let you go, though, let's go back in time to when you finally passed the bar and you're sworn in. If you could go back in time and give yourself some advice, what would you say?
Great question. And I would say, above all else, I'd say a couple things. I'd say, be empathetic. Make sure you're putting yourself in the situation of your client or who you're representing. Don't lose that connection. Don't lose that feeling, because you're going to go on with your day after you're done meeting with the client, in the office, out of the office, at the deposition, whatever it is. They may be homebound. They may not be able to get out, and you're going to go live your life. Make sure you're in that moment when you're with your client or potential client. Be listening, not here, listen. I know that when I was clerking, I talked 80% of the time and listened 20% of the time. That was a huge mistake. I did that. I was insecure. I was defensive. I wanted to try to prove to people I knew more than I did. Now, this is the exception. Normally, when I'm talking with lawyers or other colleagues or even injury victims still, or doing my pro bono work, I listen 80% of the time. I talk no more than 20% of the time. So I would tell a young lawyer, a young professional, a new associate, a junior partner, be empathetic. Don't just hear, listen. Listen a lot more than the amount of time you speak, and do something good for somebody else. We're in a privileged position, and we get caught up with running a business, running a law firm with money. We like to live a good life. You can create debt. You can overextend yourself. Make sure you're being good steward of not just the money you make, but a good steward of your talents. And if you do get a request to do something for free once in a while, and it's not outside of your wheelhouse, or you can get trained up early, that person is coming to you for a reason. Try to give a little back, because they don't have the money or the means to do something, so they're coming to you. And if you can't help get them to somebody that's vetted, that can help them. So I would say empathy, good steward of your time and your treasure, and listen a lot more than the amount of time you speak.
Rob, this has been great, man. So you don't just talk the talk. It's very clear to me and many, many other people that you're walking it as well. So you're adding value everywhere you can, and it's no surprise that you're seeing that in return. So Rod, thanks for coming on the show. It's been a lot of fun having you. And at some point we need to meet up in person. I know you're not too far from us. So
Definitely.
we'll see you in Richmond here at some point.
No question.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Niall Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.